Welcome back to Crypto Law TV. I'm John Deaton, the founder and host. Today's topic, the Hinman Deposition. Now, the Hinman Deposition that the public has received is only maybe 20% of the actual deposition. But in that deposition, there are certain questions that have been answered and certain things that have been confirmed. Now, the first thing that I'm going to go over is talk about fair notice, because as my friend Jeremy Hogan has stated a couple times, he has stated that everything is about the fair notice defense. This deposition confirmed that notion. For example, they say, don't put all your eggs in one basket. Well, if Ripple has a dozen of eggs, I'm telling you at least 11 of them are in the fair notice defense basket. So let's talk about that. I'm going to show you some of the tricks of the trade that an experienced attorney would recognize, someone who's actually employed those tricks of the trade. Now, first thing I want to explain to everyone is that when you have a witness that's not your witness and it is an adverse witness, it's not the answers that you look to, it's the questioning. The questions will tell you exactly where the attorney is headed. And that's the first thing to know. Let's turn to page 37. And it starts off with this fair notice defense, right? If you look at page 37 on line 8, it's where Bill Hinman is answering questions and he says, but no one knew a whole lot. You go down, it says, it was the early days of this activity, right? But look at the question thereafter, line 14. And this is the attorney for Ripple. And there had not been a lot of litigation as to when a transaction in a digital asset would constitute a security, correct? See, that's the fair notice defense. They're laying the foundation that when Bill Hinman arrived at the SEC, there was no litigation that gave the market participants an idea of what was going on, right? And then we fast forward to 2017, where Bill Hinman and Clayton are in charge, and then you have the ICO litigation. But Ripple didn't have an ICO. So Ripple's laying the foundation that there was no litigation that would give market participants any guidance. And then when there was litigation in 2017, they didn't sue Ripple. They didn't come after XRP. In fact, they went after all of the fraud and the ICOs. So therefore, it made Ripple have the impression that they're not doing anything wrong. On page 98 of the deposition, line 9, back to the question, because that's what we look for. There were frequent meetings. Is that fair to say? And you see the answer by Mr. Hinman. Yes, I mean, it was something that happened with some frequency at the division. Now look at the next question on line 13. And when lawyers or industry participants came to you and asked for guidance, I believe you earlier testified that the Division of Corporate Finance didn't provide legal advice, correct? And Bill Hinman's answer is, that's right. That's at the heart of the fair notice defense, basically saying that people in the industry were coming to the Division of Corporate Finance asking for advice, asking for guidance. And the division said, we don't give legal advice. We don't give that type of guidance. What's that go to? Lack of clarity by market participants of what constituted a security and what didn't constitute a security as it applies to digital assets. 172 of the deposition, down at line 20, again, we go to the question, do you recall anyone stating to you at the meeting that you recall in substance that the purpose of what Mr. Wright was working on was to explore the regulatory challenges raised by blockchain technology? But the answer is not important, right? It's Ripple laying the foundation that, look, there was a lack of regulatory clarity as it applied to blockchain technology, and people were coming to the SEC trying to figure it out. One of those people would be Ripple. Now, I told you that I would show you some tricks of the trade and how Jorge Tenrero used code to coach Mr. Hinman. All right. There's a certain way you do it, and I'm going to show you right now. Let's go back to the question on page 173, line 13. Do you remember anyone telling you in substance that entrepreneurs and others lacked guidance on how to sell tokens that should not be securities? You see that? In the question, it actually uses the phrase lack guidance. Entrepreneurs, businesses lacked guidance. And what happens? Because that is the heart of Ripple's defense, look exactly what happens next. Jorge Tenrero interrupts before the answer and says, from the outside, is that what you're asking? Someone from the outside telling him that? See, what's going on here is Jorge Tenrero is saying in code, if you will, all right, this answer hurts. So I'm going to make sure by my interruption or my objection, I'm sending a signal to Mr. Hinman that be careful about your answer. Now, Mr. Feigl says, yes, sorry. And then, as you can see on line 21, Ripple's attorney says, did you understand my question? Now, Mr. Hinman is a very intelligent person. Okay, he didn't get where he's at for being dumb. What's his answer? Page 174 at the very top. Why don't you repeat it? Right now, do you really think that Mr. Hinman needs the Ripple attorney to ask the question again when it's simply people are coming to you, entrepreneurs saying that they lack guidance? But it's giving him time to formulate the answer. So because he gives himself time, now the Ripple attorney starts asking the question again as Mr. Hinman is thinking of his response. And so the Ripple attorney says, I'm focusing you on the meeting that you recall. And Mr. Tenrero's observation that you don't remember the date, which I understand. I think the record's clear on that. I'm now asking you if you recall that during that meeting that you remember, you were told in substance that entrepreneurs and others lack guidance on how to sell tokens that should not be securities. Answer, after all of the time that he's been given and provided now, I don't have a specific recollection of that being said to me at that meeting. No. Okay, that is classic lawyer. Some would call it manipulation. Some would call it good lawyering. I'm not calling it anything other than calling it exactly for what it is. That is a lawyer. And I'll be honest with you, I've done it with my witnesses, except I'll tell you something, there's a difference. I represent people who are on chemotherapy, who are dying and sick. And when they ask a question by a skilled attorney, when they're fatigued, okay, and running out of oxygen to speak, it's a little bit different when you interrupt and you do a little coaching. We're talking about the director of corporate finance at the United States Securities Exchange Commission. I don't think Mr. Hinman needs all that type of coaching or time and all the tricks of the trade that we usually use for regular people or people such as my clients. Let's move on to page 218 to 220. That shows you, again, everything. Let's go down to the line 16. As of April 26, 2018, had the Division of Corporate Finance issued an interpretive relief about the circumstances under which a digital asset transaction could be an investment contract or a security? That's the question, right? Answer, did you say, quote, interpretive release? Question, Answer, no. Let's go to page 219, and there's another question on line 4. As of April 26, 2018, had the Division of Corporate Finance issued a regulation about the circumstances under which a digital asset transaction would be an investment contract or a security? Answer, no. That's the defense. You could sum up the fair notice defense on page 219 in that question, in that answer. Right now, line 10, and the Division of Corporate Finance had not engaged in any rulemaking activity about the circumstances in which a digital asset transaction would be a security, correct? What does Mr. Tenrero do? I object to the form and also instruct the witness not to answer internal deliberations about potential rulemaking. Are you talking about rulemaking activities externally, such as requesting notice of comments? Or Mr. Figo says yes, Mr. Tenrero says okay. And then again, this is signaling to Mr. Hinman. We go on and Mr. Figo says public announcement of a potential rulemaking as to when a digital asset transaction would be viewed as a security under the federal securities law. Answer, no. And that is all guidance that could have provided, correct? In other words, it's saying the SEC and the corporate finance could have provided that guidance. And the answer there is that's a form of guidance, yes. At least in 2018, there was no guidance to the digital asset community. As far as April, I should say 2018, because we know in June, on June 14th, 2018, we get to the famous Mr. Hinman's speech that Bitcoin and Ether are not securities. But this is Ripple basically laying the foundation that until that speech of June 2018, the market lacked complete guidance in what was considered which digital asset transaction would constitute a security. 258, line 16. Do you believe that Mr. Seaman wrote, you call 10 different law firms, they give you 10 different answers? And the answer is no. Now, again, why is that important? That's basically saying that, listen, even if we go seek lawyer advice, one lawyer is going to say this, another lawyer is going to say that. And so when you have that lack of clarity, even with experienced securities lawyers, then there's no guidance. They look to the SEC for the guidance, and the SEC is not providing any, okay? Classic fair notice type issues. Now, if you get to page 323, line 16, it states, when you joined the SEC in May of 2017, did the SEC have a policy against owning digital assets? The answer is, I'm not sure. Now, Ripple knows, as Jeremy Hogan stated, they know the dates and they have the documents, right? The next question is, isn't it a fact that the policy against owning digital assets wasn't instituted until 2018? Mr. Tenrero objects. And then Mr. Hinman, because he knows it hurts, says, I'm not sure that's right. And then the question is, when do you think it was instituted? And then they go on. I'm not going to go through all the answers, but what's important here is that Ripple is stating that up until 2018, unlike equities and securities in the stock market, there was no policy relating to someone like Mr. Hinman or the chairman or any SEC staff member or lawyer. There was no policy that they couldn't own digital assets, right? What's that say? What's that imply to the market? It says that if you can own a digital asset, then it can't be a security because the SEC has a policy on owning securities. And if there is no policy as it relates to digital assets, we don't consider it a security, okay? This is the heart of fair notice. This is the heart of what Ripple's getting at. This could give Ripple a free pass from 2013 to 2018, right? Because in 2018, they instituted a policy that the SEC staff couldn't own digital assets. But from 2013 to 2018, it's free game, right? It is an absolute, you can own them. We're not even thinking about digital assets as securities. If they did, why wouldn't they institute a policy immediately? The truth is because they didn't consider it securities. Let's just call it like it is. They didn't. And this proves it. The last thing on fair notice that I will show you is that we get to page 407. You'll see there that Brad Garlinghouse's attorney, Mr. Solomon, after Mr. Tenrero does a lot of leading objections and he gets out the fact that Mr. Hinman at some point in time in 2020 told the Ripple folks that he viewed XRP as a security. Mr. Solomon brings us back to an earlier time in 2018 at an August 2018 meeting. If you look up on line 4, Okay, and to be clear, by August 20th, 2018, you had delivered your speech to the marketplace where you gave your view that neither Ether nor Bitcoin are securities. Is that correct? And the answer is yes. Okay, now the next question talks about this memo that comes from that August 20th, 2018 meeting. And in this memo, there was a discussion involving my client, which is Brad Garlinghouse and David Schwartz. Okay, I believe so. That's what the memo says. But then you go down to the question at line 17, and it looks like there's also a notation that towards the end of the meeting, Garlinghouse briefly noted that Ripple was in purgatory due to uncertainty as to whether XRP, the cryptocurrency with which Ripple is associated, is or is not a security. Do you see that sentence? The answer on page 408, I do. Okay, so two individuals who attended that meeting were reporting back to an internal memo that at this point in time, in August of 2018, my client had orally indicated that there was uncertainty around the status of XRP. That's what this memo establishes, right? Answer, the memo says that. It says what it says, okay? That's good lawyering by Mr. Solomon, even though Mr. Tenrero put on the record that Bill Hinman had informed Ripple and their attorneys that he viewed XRP as a security. That was in 2020, just several months before the lawsuit. But as late as August 2018, which is a couple months after the June 2018 speech, Mr. Garlinghouse is declaring we are in purgatory because of this uncertainty. Goes back to that 2013 to 2018 potential free pass based on fair notice. Now, the last point I'd make about that is that if you look at the bottom of page 408, the question goes on to say that the memo goes on to say, in response to Mr. Garlinghouse saying, we're in purgatory. We're in purgatory because of the uncertainty related to XRP. Chairman Clayton immediately stated that the meeting was not the proper forum for a discussion about that topic. Do you see that sentence, sir? Yes. Question. So there's no note in here that Chairman Clayton responded that there is clarity around whether XRP is a security, right? That's not in the memo. I don't see that in the memo. Do you? I don't see it. Okay, basically, that is Ripple establishing that with the chairman of the SEC in 2018, in August, which is 2 years before they were sued by the SEC, the CEO of Ripple says to the chairman of the SEC, we are living in purgatory because of the uncertainty on XRP and whether it's considered as a security or not a security by the SEC. And the chairman of the SEC does not say to Mr. Garlinghouse at that meeting, I'll give you clarity, it's a security. He didn't say that. All right, there's no mention in that. Instead, Mr. Clayton says to Mr. Garlinghouse, I would encourage you to continue these conversations with the staff of the SEC. In 2018, there was no clarity for Ripple as it relates to XRP. That's the argument. Now, what we'll learn is that in 2020, Mr. Hinman testified that he told Ripple's lawyers that he viewed it as a security, but that's several months before they were sued. So you see how big the fair notice defense is?